discovery, but he says he's just going to send it to me. So I haven't looked at that. But I did receive an offer, and I've been talking with Mr. Maple, and it's getting to the point where we really can't even communicate.
This is a big red flag in criminal cases, discovery problems. Anytime a defendant says there's a missing video, the judge's radar activates. Evidence delays can derail negotiations, plea deals, and trust between attorney and client. Viewer question: have you ever seen a case fall apart just because of one missing file?
Productively about this case, and I feel like it needs a different lawyer.
All right, Mr. Hughes, what is your issue?
This case is...
Well, no, I'm not talking about the facts of the case because I don't know the facts of the case. I'm talking about your communication with your attorney. I will tell you about this court. I require that everyone treats everyone with respect. I don't care what your occupation is. You can be a neurosurgeon, you can be the president, you can be the person who does the lawn, or the person who delivers the grocery to the grocery store, or an Uber driver. Everybody needs to be treated with respect. So my question to you is, what is your issue with your attorney and communication?
I just feel like I'm not able to provide her. I can't convince her that how.
Well, here's the thing. With regards to convincing people, sometimes what I've discovered in my short time on the planet, even though more of my life is behind me than in front of me, I still consider it a short time on the planet. Sometimes people don't want to hear truths. I call them home truths. Sometimes you have children, when you tell them you can't have candy for breakfast, they don't want to hear that. They want candy for breakfast, right? And sometimes when you have clients, and I've been a defense attorney, they don't want to hear what's in the police reports. They have their own idea of the way a case should be tried.
This is textbook courtroom management. Judges emphasize respect because the courtroom is built on procedure, not emotion. When communication between client and attorney breaks, the legal strategy collapses fast. Watch how the judge subtly resets the power dynamics.
When really they're not in charge of strategy, their attorney is. And I know that some people think I can be an attorney. And my opinion on that is, if you could be an attorney, then you would be an attorney. Your attorney went to school. She has a law degree, and she went to school to be an attorney. And I do know that at a minimum, she has probably at least 7 to 8 years higher education to be an attorney, because she at least has a bachelor's degree. And because she's here, we know she has a JD, and we also know she took the bar and she passed the bar, because otherwise she wouldn't be here. So again, what is your issue?
Okay, so my issue is it's probably going to be my inability to express to her that my cousin was killed in a double homicide. Matthew Lopez. The feds were involved.
All right, so here's my thing about that. I understand what you're saying. I sympathize with you. But you're charged with stalking.
Right.
And unless somebody was there at that stalking.
Well, just as a thing, my brother was killed right after he came home from prison. My belief is that he was...
Okay, no. Here's the thing about that.
Okay, I'm sorry.
I'm sure your attorney would tell you not to speak to me about the facts or what you believe the facts of your case to be.
Right. Well, you said respect, so you cut me off twice.
Yeah, I am cutting you off because, and I'm cutting you off for your own benefit. Your attorney would not want you speaking to me about what you perceive the facts of the case to be. And let me just tell you why they probably don't want you speaking to me about the facts, because the state is...
Classic judicial reality check. When a judge lists the attorney's education, that's not small talk, it's a warning shot. Translation. This is your lawyer. They know the law. You don't. Stay in your lane. Judges do this to re-establish credibility and prevent defendants from trying to outlawyer their own counsel.
Here, the state is going to be putting on a case and prosecuting the case against you. And I don't think any attorney would want you telling me what your defense may be or what you believe the facts will be, because then the state will know that. Am I correct, Ms. Livingston?
Basically, what I'm saying is, I was not stalking. I was just trying to investigate if I was threatened, if I was going to be a threat of a threat, if I was threatened by the same thing that was, if my house got shot up, you know. So I was trying to figure out.
All right, Ms. Livingston. Do
Do
you want to continue to represent Mr. Hughes?
No, I think that he deserves an attorney that can, he feels like he can explain things to, and who will represent him.
This is dangerous territory. A defendant explaining case facts directly to the judge while the prosecutor is present? That's like giving the opposing team your entire playbook. Legally, this is why attorneys panic when clients start talking too much in open court.
Zealously, I don't think that I can do that.
All right. So, Mr. Hughes, I'm going to allow Ms. Livingston to withdraw from your case. State, are you going to have any objections to that withdrawal?
No objection.
All right. So, Ms. Ferguson,
Yes.
we're going to appoint a different attorney to Mr. Hughes. Mr. Hughes, we're going to have a different attorney appointed to you. Do you have an issue with that? All right. So, if you'll take a seat in the box. Thank you. So, I see Carl Alexander and present back to me. So, Carl, if you will speak to Ms. Ferguson.
May I have
Thank you.
excuse?
Yes. So are you available, Mr. Alexander?
Certainly, Judge. I'm working on a plea right now.
All right,
So I'm on a trial docket. We're going to get taken care of. I'll introduce myself.
okay.
Obviously, ask for a recess. 'Cause
Yes.